My name is Michael. I'm a lawyer here in Ontario. I'd like to read one of the questions in P1Law. Very interesting. This is a free question. The question is this. When a court reviews an administrative decision, it starts with the presumption that reasonableness is the applicable standard. This is in one way deference from the court to respect the decision of the administrative tribunal. But there are certain situations when this presumption may be rebutted and the reviewing court applies the standard of correctness. In which of the following situations may the presumption of reasonableness review be rebutted? There are three answers to this question, and that's what the app is saying. Letter A, when the reviewing court is more expert than the administrative tribunal in deciding the issue brought forth in the review. Letter B, when there are inconsistent decisions of administrative tribunals on a particular issue. Letter C, the legislature has provided a statutory appeal mechanism from an administrative decision to a court. Letter D, when the review by the court involves constitutional questions. And letter E, when the review by the court involves general questions of law of central importance to the legal system as a whole. Oh, pretty tough question here. And we're required to choose three answers. Just thinking, I think the answer to this question is letter C, D, and E. Letter C being the legislature has provided a statutory appeal mechanism from an administrative decision to a court. That signals that it's a standard of correctness that the legislature intended it to be. Letter D also is the correct answer when the review by the court involves constitutional questions. And letter E, when the review by the court involves general questions of law of central importance to the entire legal system as a whole. So those are the answers. And as a professional context, this question belongs to the category of administrative law, subcategory of public law, basic principles. And the topic is on the standard of review of correctness. This is a free question from the P1Law app. The answer basically has been stated and explained in one of the cases in the Supreme Court. This case is Canada Minister of Citizenship and Immigration versus Vavilov. The citation, and this citation is available in the P1Law app, is 2019 SCC 65 Canley. It's also cited as 2019 for SCR 653. In this case, the Supreme Court of Canada enumerated the situations where the standard of correctness may apply. And there are 5 points that you have to bear in mind. The first is that if it is the express legislative intent to make the standard be that of a correctness, for example, that is when the legislature clearly intended that a different standard of review should apply. That's one factor you'll have to consider. The second factor is if appeal was provided by the statute. The third factor is that if the questions involve constitutional questions, such as division of powers between Parliament and the provinces, that the tribunal or the administrative agency has no power at all to decide. The fourth factor you have to consider is that does it involve general questions of law of central importance to the legal system as a whole? And the last factor is, are the questions related to the jurisdictional boundaries between two or more administrative bodies? Basically, the last point is a question among those administrative bodies which they cannot decide themselves. And so they need some third party, which is the court, to decide that question of jurisdictional boundaries. Yeah. If you have further questions.
What are the key terms that the students must be aware of within this question?
Okay, just reading through the question. Key terms here is the standard of correctness versus the standard of reasonableness. The student must bear in mind that the principle nowadays is for courts to give deference to the administrative body, give it some kind of respect. The administrative body was created by our legislature, and so courts must at least respect that decision of the legislature creating that administrative agency. And so you start with the standard of reasonableness, and the court should not interfere with that decision unless it finds it to be unreasonable.
Why is it important that legal professionals know about this Vavilov case?
It's important for them to know about this case because before you decide to go on a judicial review of a client's case, or if you want to go to the courts and get their relief from the courts, you'll have to analyze the situation and you'll have to weigh in the different factors before deciding to go to the courts. Otherwise, if you just blindly go to the courts without weighing in these different factors here, there's a big chance you're not going to make it.
And what is the core principle behind the answer?
The core principle here is you start with standard of reasonableness, and from there, there are some exceptions. There are certain exceptions, and if your case happens to fall under any of those exceptions, then you might have at least a chance pursuing it. And it's really important for you to know these exceptions. Like, for example, if it was expressly placed in the legislation that the standard should be standard of reasonableness, then that's the standard that should be applied. Let's take a different view. If the legislature intended it to be a standard of correctness that should be applied, then they will place it in the legislation. If there is an appeal that's available, it only means one thing. It means that the legislature intended that the decision of the administrative tribunal must be reviewed by the court. And so a standard of correctness is likely more to be applied. Third is if it's a constitutional question. If it's a constitutional question, then most likely the tribunal will not be able to answer it themselves. Fourth is if it's a general question of law of central importance. Like, for example, if it involves solicitor-client privilege for which the administrative tribunal does not know how to approach it, then a standard of correctness must be applied here. And the last one is if the questions relate to jurisdictional boundaries. The administrative tribunals themselves don't know how to settle their jurisdictions. Then they need a higher or a third party, our courts, to determine it for them.
What is the Vavilov case, and can you tell us a little bit more about it?
Vavilov case. So this is cited as, I already provided the citation. It's in Canley, Canada Minister of Citizenship and Immigration versus Vavilov. It's a 2019 SCC 65, Canley, 2019 4 SCR 653. This is a case of a child of two foreign nationals. Vavilov was born here in Toronto way back in 1994. However, he didn't know that his parents were Canadians under assumed names. They were foreign nationals working on assignment for the Russian Foreign Intelligence Service. But he did not know. Vavilov did not know that his parents were not as they claimed to be. However, Vavilov knew, as far as he's concerned, that he is a Canadian citizen by birth, that he held Canadian passport, identified himself as Canadian. So in 2010, his parents got arrested in the United States for espionage. They were charged with espionage and they were sent back to Russia. Since then, Vavilov had difficulty. Actually, he was unsuccessful in renewing his passport. Worse is that in 2013, in 2013, he was issued the certificate of Canadian citizenship. But shortly after that, 2014, the Canadian Register of Citizenship canceled his certificate of citizenship, saying that under Section 3, 2, and A of the Citizenship Act, he is not a Canadian citizen by birth. That act actually exempts children of diplomatic and consular officers or representative or employee of in Canada of foreign governments from the general rule of birthright. Birthright meaning if you're born here in Canada, you automatically become a Canadian citizen. So Vavilov, finding his certificate of citizenship being canceled, went to the courts on a judicial review. Unfortunately, the federal court dismissed his application. Unfazed, he went all the way to the Court of Appeals. This time, the Court of Appeals allowed the appeal and quashed the decision of the Registrar of Citizenship. And they stated that it was unreasonable. This time, it was the Minister of Citizenship and Immigration that appealed to the Supreme Court. The Supreme Court dismissed his appeal. In other words, Vavilov won this case. The Supreme Court stated that it is not reasonable for the Registrar of Citizenship to interpret Section 3, Subsection 2, Subsection A of the Citizenship Act as applying to children of individuals who did not have diplomatic privileges at the time the child was born. So this is really a very interesting case, and it's with a happy ending for Vavilov. Thank you for having me. My law office handles immigration law, family law, criminal law as well. Visit us at macnlaw.com and also use the P1Law app at www.p1law.com. Thank you.